morning, everyone, and welcome to the Supreme Court as we celebrate Law Day 2014. This year's theme is American Democracy and the Rule of Law, Why Every Vote Matters. The American Bar Association's website states, and I quote, "As we approach the 50th anniversary of the Civil Rights Act of 1964 and the Voting Rights Act of 1965, the 2014 Law Day theme calls on every American to reflect on the importance of a citizen's right to vote and the challenges we still face in ensuring that all Americans have the opportunity to participate in our democracy." As we look around the world, we see many people fighting for the freedom to select their own leaders. This is a right that we Americans often take for granted. This is unfortunate because hundreds of thousands of people from all walks of life have sacrificed their lives for this right. Regardless of your political affiliation, I think we can all agree on one thing. Our forefathers intended this country to be defined as a democracy that elects its leaders by the people. This is the social compact that the people make with the leaders of this country. In exchange, the people agree to some measure of authority over their lives by government. This is necessary to ensure an orderly society and highlights the importance of an individual vote. It's now my great pleasure to introduce to you our keynote speaker, Dr. Douglas M. Spencer, who is an associate professor of law and public policy at the University of Connecticut School of Law. He holds a master's degree from the University of California, Berkeley, Goldman School of Public Policy, a JD from the University of California, Berkeley School of Law, and a PhD in jurisprudence and social policy, also from Berkeley. His current and recent research centers on the institutional regulation of elections at the intersection of law and political science. Dr. Spencer is a wealth of knowledge and experience studying the regulation of America's political process, with emphasis on election policies and the Voting Rights Act. So I'm pleased to be able to invite Dr. Spencer to address us this morning.
Chief Justice, Justices, and judges of the court, friends and colleagues, thank you so much for having me here today. I'm honored to have been invited to talk to you about American democracy and the rule of law. And I want to begin by sharing a personal anecdote of how I got interested in studying the law of democracy. So my research focuses on election law and election administration. In one particular project, in 2008, I recruited 150 undergraduate students and dispatched them to several dozen polling stations and had them observe various elements of the voting process. As part of the project, I went myself and spent 4 hours in the home garage of a local poll worker where there was a polling station. And I tallied the arrival time of every voter, the number of minutes they spent checking in, the number of minutes they were in the voting booth casting their ballot. And the purpose of the project was to try to figure out how and why long lines form at polling stations on Election Day. Ironically, I ended up spending a lot of time sitting all by myself in an empty polling station. No lines, no voters. And as it turns out, the vast majority of polling stations in America are empty for large parts of the day on Election Day. Now, about 60% of eligible voters turn out to vote for the president every 4 years. About 40% of eligible voters turn out to vote for senators and representatives during the midterm election. Far fewer voters show up to vote for state and local offices in off years. So as an example, a local example, last year, just 5% of Hartford voters showed up for the school board election. Makes you wonder, what would happen if we held an election and nobody showed up? Some people think that this is a problem that's squarely on the shoulders of voters. So the great President Abraham Lincoln once said, "Elections belong to the people. It's their decision. If they decide to turn their back on the fire and burn their behinds, then they will just have to sit on their blisters." Well, that could be a big problem because in virtually every election in America, the number of people who come and exercise their right to vote are far outnumbered by the number of people who stay home. To many people, low turnout signals that something's wrong, that there's general apathy about politics, and low turnout undermines the legitimacy of our elected leaders because really they're elected by a minority of the population. These people might be right. Turnout might be a bad thing. Low turnout might be a bad thing. But I think that the issue is a little bit more nuanced. So some scholars have noted that non-voting could be a sign of contentment and a satisfied electorate. In other words, low turnout could theoretically be a bad thing, but not necessarily. And let me explain why. If the 40% of the population that shows up to vote is representative of the entire population, then the outcome of an election is both accurate and legitimate. What I'd like to press upon you today is the idea that the number of voters, as important as that is, may not be as important as the representativeness of the voters that turn out. And by representativeness, I mean that the choices of those who turn out represent the will of the entire eligible voting population. In America, low turnout is problematic, precisely because those who vote are not representative of the population as a whole. As many scholars have discovered when they look at voting, those with more education and higher incomes are far more likely to turn out to vote than those who are less advantaged. They're far more likely to engage in the political process, to donate money, to send letters to the representatives. The people who are the least likely to be content and satisfied with the system, and the most likely to need the government's help, in America are the least likely to vote. This striking fact raises an important jurisprudential question. How should legislators, lawyers, and judges account for this deficit in electoral representation? Voting rights doctrine has long been dominated by a rights and interest balancing test. So according to the United States Supreme Court, the only cognizable harm of a restrictive voting law, like a photo ID law, or a proof of citizenship requirement, or cutting back early voting days and the like, is that they inflict a burden on the individual right to vote. And that burden is tolerated if the restrictive law is deemed to be closely related to the state's interest. This balancing misses the forest for the trees. And let me explain why I think that. And I'll draw on 3 examples from a recent paper by a University of Chicago law professor. The uproar over photo ID laws and cutbacks to early voting has not been based on concerns about individual liberty or even turnout. The primary concern with these laws is that they disproportionately prevent certain kinds of voters: the poor, racial minorities, students, etc. So the effect on turnout is uneven, meaning that these laws could have an impact on the outcome of an election. The fear of partisan distortion is actually fueling this controversy, not so much a concern about individual liberty. The same concern is central to the debate about redistricting. The case law on redistricting is also rooted in the individual rights framework. We have the idea of one person, one vote. It's a doctrine from the Supreme Court that represents a commitment to an equal opportunity for participating in the political process. But the most glaring problem with gerrymandering, the very problem that gave us this name, that spawned the name gerrymandering, is that clever configurations of electoral districts can result in legislatures that don't represent the preferences of a majority of the voters. Consider that in 2012, Democratic candidates for the U.S. House of Representatives received 170,000 more votes than Republican candidates. Yet Republicans won 33 more seats in the House. A similar mismatch occurred in the state legislatures in Michigan, North Carolina, Pennsylvania, and Wisconsin, where one party's candidates earned more than 50% of the votes, but only won 30% of the seats. The controversy over gerrymandering, the injury that it imposes, is ultimately less about the individual right to vote and more about the misalignment of preferences between legislators and voters. Finally, the same logic applies to the regulation of campaign finance. It is undisputed that the role of money in politics is enormous. Campaigns are costly, and as a general rule, the candidate that spends the most wins the most often. The need to raise money has made our candidates more and more reliant on wealthy donors and organized special interests. The federal courts have recognized only one cognizable harm from this spending in politics: individualized quid pro quo bribery. But equally troublesome, in my mind, maybe more troublesome, is the fear that candidates will adopt the policy preferences of their donors instead of their constituents. To the extent that these donors are not representative of the majority, we may elect candidates who don't represent the will of the people. So in all of these cases, restrictive voting laws, redistricting, campaign finance, one core problem is the possibility of misalignment between the preferences of all eligible voters, the collective will of we the people, and the preferences of our elected representatives. My goal in raising this point today is merely to suggest that alignment of these preferences should be part of the decision calculus in shaping new election reforms and in adjudicating cases about the regulation of elections. Alignment is central to the Republican form of government, which we've been promised in Article 4, Section 4 of the U.S. Constitution. Misalignment is a political harm. So there is no doubt that individual rights and state interest balancing will continue to be central to judicial decisions about elections, as it should be. But those who pass new laws, those who interpret these new laws, those who enforce these new laws, should also be thinking about their impact on alignment in determining the effectiveness or constitutionality of the laws. So let me conclude where I began, which is sitting in an empty polling station. The polling station actually wasn't empty all day. I was there for a few hours. I saw more than 100 voters come to cast their ballots. Voters of all stripes. Young mothers who brought their kids, 20-year-olds who were voting for the first time, Latinos, Asians, blacks, whites, an old gentleman who was leaning on his wife figuratively and literally as he came, voters that were disabled. And I think now especially we're celebrating the 50th anniversary of the Voting Rights Act next year, the 50th anniversary of the Civil Rights Act this year. It gives us a moment to pause and to think about the progress that we've made. More people have the right to vote now than they did when our country was founded. More people have the right to vote now than they did 50 years ago when we enacted the Voting Rights Act. The alignment of our government to the preferences of the people is much better now than it was when our country was founded. The alignment of preferences between our government and the people is much better now than it was 50 years ago. And I'd like people to not forget that, because virtually every adult citizen in America is afforded the franchise of voting. So that's the optimistic tone. There are still fronts where there are attacks on voting rights, and we must be vigilant in carrying forward the mission that we started 50 years ago in helping to push forward the idea that every vote matters and that larger populations are afforded this franchise and not left out, as much because there's an individual liberty to the fact that we would like the vote to actually represent the will of the people, which is the purpose of having this in the first place. I appreciate you having me here today. I look forward to meeting some of you, and thank you very much.
Thank you, Dr. Spencer. I'd now like to introduce Attorney Kim Knox, President of the Connecticut Bar Association, who has graciously accepted our invitation to deliver remarks on behalf of the Bar Associations. Attorney Knox previously served as the CBA's Vice President and Assistant Secretary-Treasurer. She also served as the Chair, Vice Chair, and Secretary-Treasurer of the Litigation Section, and was a founding co-chair of the Appellate Advocacy Committee and the Appellate Advocacy Institute. Attorney Knox, in addition to all that, has been a principal in the Hartford law firm of Horton, Shields & Knox since 1989. And on a personal note, I've had the pleasure of working with her over the last year, and we're going to miss you. So thank you for all of that. And with that.
Good morning, Chief Justice, justices, judges, colleagues, friends, and everyone here who has joined us. And a special thanks to our keynote speaker, Professor Spencer from the University of Connecticut School of Law. On behalf of the Connecticut Bar Association, I'm honored to be here today to speak about this year's Law Day theme, American Democracy and the Rule of Law, Why Every Vote Matters. That's a really big title, and there's a lot of parts to it. One of the things I do want you to take away, though, is to always remember, it's a phrase you've probably heard, maybe for the first time, but the concept of the rule of law, because that's going to be a phrase that you will hear over and over again during the course of your life. President Lincoln most eloquently described the importance of the right to vote within the context of the rule of law when he stated that we are a government of the people, by the people, for the people. And it is this rule of law principle enshrined in our nation's founding documents that assures that our government derives its power from the consent of those who are governed. The right to vote plays a significant part in American legal and civic history. But the genesis of the right to vote is in the United States Constitution. It is noteworthy that the regulation of voting in elections, however, is vested by that Constitution in the states. As Professor Spencer noted, state laws limiting voting eligibility by qualifications have plagued our history, and that's why we're here today to celebrate. I want, as we stand here in this particularly historic Connecticut Supreme Court room, to consider the Connecticut history in context of national events, because we have our own interesting twists and turns. In Connecticut, there was something called a Constitutional Convention in 1818. Prior to that time, Connecticut was ruled by Federalist laws, under which the right to vote was limited to white men who served in the militia or who paid taxes. Beginning in the early 1800s, there was a movement here in Connecticut to narrow eligibility even further. In 1813, an act passed requiring that the real property used for voting eligibility be free of a mortgage and that voters have personal property, which was increased by over 40%. That was a very limited voting body. By the state elections in 1818 and 1817, there was a shift in political power. What a relief. In 1818, the General Assembly, with many newly elected members, reestablished the more expansive right to vote to all white males who paid taxes or were in the militia. There was a whole lot of people excluded, including myself at that time, as a woman. More importantly, the General Assembly called for a constitutional convention, as I mentioned. The Constitutional Convention is a very historical moment in Connecticut, and it's probably one of the most well-documented conventions because of the work done by the then Hartford Courant. Carried the transcripts of what happened during the convention in great detail. One of the hotly contested issues was the right to vote. One fascinating amendment was proposed by Stephen Mix Mitchell. He was Connecticut's first Chief Justice of the Supreme Court. He wanted to eliminate the words, quote-unquote, white male from the eligibility requirements that included, quote, every white male citizen of the United States. This is 1818. Think of what he was proposing then. It would have effectively eliminated the race and the sex limitation. But in the end, and by a very narrow margin, the right to vote was only preserved for all white males who paid taxes or in the militia. And they had to fight hard to get that. Between the 1818 Constitutional Convention and 1965, the Connecticut Constitution was amended 59 times. With regard to the right to vote are the following significant amendments. In 1845, the property qualification, the militia clause, and the state tax payment clause were eliminated. But in 1855, the ability to read was added. So you had to be able to read and prove it to vote. In 1876, the, quote, white qualification was eliminated. But in 1897, the ability to read English was added. The elimination of the reference to, quote, white before male followed 6 years after the adoption of the United States Constitution's 15th Amendment, which prohibited the denial of the right to vote at the state or federal level on the basis of race. But it was not until 1955, a constitutional amendment, that Connecticut eliminated the restriction to males and acknowledged that women had had the right to vote for over 30 years as a result of the ratification of the 19th Amendment to the United States Constitution in 1920. Today, the Connecticut Constitution provides that every citizen of the United States who is 18 years old and a bona fide resident here in a town in Connecticut is qualified to vote. Today, we celebrate the 50th anniversary of the Civil Rights Act of 1964 and the Voting Rights Act of 1965. And we also celebrate the leaders of the day who valued the right to vote as critical to our rule of law. But the discussion of the protection of the right to vote does not end. Today, we must recognize that persons may be disenfranchised as a result not only of voting eligibility requirements, but also as a result of voting processes. Access to the polls on voting day in terms of long lines, closing times, or limited ballots, accessibility to the voting process by military personnel, students, and others who may be out of state, and the mechanics of registration are just some examples of potential impediments to the right to vote. The CBA has been active in protecting the right to vote. For example, last year, the CBA supported the adoption here in Connecticut of the Uniform Military and Overseas Voters Act to ensure that military members and their families living away from their residences at the time of an election were provided the infrastructure to cast a timely and meaningful ballot. During the past 2 years, the Connecticut Bar Association has also worked with the Secretary of State's office to ensure an accessible and orderly process of voting at Connecticut polling venues. In closing, the right to vote is at the very core of government by the people. And as I see a number of young people here who will either have or soon have the right to vote, I want to have you remember the history of the right to vote. Remember, it is never to be taken for granted that many people fought very hard that every one of us in this room have that opportunity. Never take it for granted, protect it, and exercise it. Thank you very much.
Thank you, Attorney Knox. We appreciate your taking time on behalf of the CBA to come here today. Before we adjourn, I'd like to recognize the students who have joined us today. We have students from Capital Preparatory Magnet School in Hartford and Bloomfield High School. So they're here today in conjunction with a Law Day program sponsored by the law firm of Shipman and Goodwin. And I'd ask for the students to please rise now so that you can be recognized. And hopefully someday down the road, we'll see at least some of you here as attorneys standing right in front of us arguing your case on behalf of your clients. We look forward to that. At this time, we're going to conclude our ceremony, and we would invite all of you to join us next door in the Museum of Connecticut History for a reception. And again, thank you all for coming today.